People versus Michaela Mayberry. I'll take entries. I'll start first, Ms. Becker, with you.
Amanda Becker for the people.
All right, and I note this matter was set at 1 p.m. for a motions hearing. It's currently 1:03. Ms. Mayberry does not appear. I'm going to give her to 1:05, and then we're going to move forward. Ms. Becker, can you remind the court, has there been any failures to appear in this case?
Your Honor, I was just looking at that. We did have ones early on, and she did have to be extradited from Texas. But she has been since on bond and in Colorado and appearing for the last several. Our last FTAs weren't since August of 2023. She also has a revocation matter in Adams County. She did appear at their last hearing in October of 2025. And then I just checked Vine Link and she does not appear to be in custody.
Okay.
Give her to like 1:15.
Okay. All right, we'll wait 10 minutes. Back on the record in 23 CR 884. I'll note for the record that it is now 1:20. This matter was set at 1 p.m. Ms. Mayberry does not appear.
Given that there was the older FTA, the age of this case, and that we have had to extradite her from Texas, I do think the $20,000 cash surety is appropriate. She also has somewhat of criminal history for VPOs primarily, and some other trespass to dwellings. So also a history of not complying with court orders, which is also why I'd asked for the $20,000 cash surety. All
right, what the court's going to do, I'm going to find that Ms. Mayberry has failed to appear. I'm going to revoke her bond. Court's going to issue a warrant. Court will set a new bond in the amount of $20,000 cash or surety that is based on Ms. Mayberry's prior history of failing to appear, as well as her criminal history and the severity of the underlying charges in this case. We'll maintain our trial dates, and I think we need to see when Ms. Mayberry is picked up and go from there. All right, we're going to set this over for Thursday at 1 p.m. 1 p.m. Ms. Mayberry, you need to be there right at 1 p.m. Court's going to call at 1, and we're going to move forward. Court will quash the warrant that was previously issued. Ms. Becker, is there anything else? Any discovery updates?
Thank you. Your Honor, I did want to alert the court. I did provide Ms. Mayberry a copy of all of the discovery in this case today via a USB. I also had her sign a document noting that she's received that discovery. It does have all the both media and the PDFs in this case. I did also get a good email address for her today. So if there are any trial preps that create potentially new discovery that we usually create around trial preps, that would be the only thing we would be emailing her new. Otherwise, all the discovery is in. And then lastly, the people did just want to make a brief Lafleur record.
Yeah, please go ahead.
Thank you. Ms. Mayberry is charged with a Class 3 felony for burglary that has the possibility of 4 to 24 years in the Department of Corrections. It is, we do consider her enhanced due to a case being open at the time, which is Adams 20 CR 4209. That's what makes the enhanced range 4 to 24 years. She is still probation eligible, even if convicted at trial. The offer on this case was to a Class 4 felony for burglary in the second degree and a Class 5 felony for palpo, which is possession of a weapon by a previous offender. That is also the enhanced range with the possibility of 2 to 12 years and is still probation eligible.
Okay. Ms. Mayberry, do you have any questions about that? Okay. What part of the verbiage?
All of the verbiage of it.
So let's, I guess, break it down then. Ms. Becker, the offer is to...
It would be for a slightly lesser felony. It's still called a burglary in the second degree, but it's one step down. That's why you go from a 4 to 24 range to a 2 to 24. And then a Class 5 felony for palpo, which we would, if she was sentenced on both the F4 and the F5 palpo, we would ask for a sentence together in that range of 2 to 12 years.
And the palpo is possession of a weapon by a previous offender. So if you proceed to trial, the potential sentencing range that the court can impose is 4 to 24 years. The offer is a plea to a charge which would set the sentencing range from 2 to 12 years. Okay. Because we're proceeding on this case, the district attorney is making this record because there's not going to be any further offers. We're going to proceed to trial on this case. Do you understand that?
Yes, Your Honor.
Okay.
The people don't object to a bifurcation. I do think that makes sense to do the Palpo and the VPO after the other two charges. And for defense 8, for the motion in limine, the people would not be presenting Ms. Mayberry's prior criminal history unless she were to testify at jury trial.
All right, we're back on the record in 23 CR 884. I'll indicate that Ms. Mayberry is present. Ms. Mayberry, you were late today. What happened?
I'm sorry?
You were late today.
5 minutes?
Yes, I told you on Tuesday that I wasn't going to have you late for today's hearing. You need to be on time.
I have to take public transportation, Your Honor.
I told you about this hearing on Tuesday. You could have made arrangements to be here on time.
And yes, I did.
And you
Got
were
here
late.
As soon as I could, Your Honor.
Okay, what I'm going to say, Ms. Mayberry, we're set for trial. If you are going to be late for any of those trial dates, I'm not going to keep the jury waiting for you. I will remand you into custody for the trial if we need to do that to make sure that you are here on time, okay? We have people waiting. You need to be on time. We're going to go forward. Ms. Becker, we're going forward on the defense's motion to suppress show up identification. Are the people prepared to proceed?
Yes, Your Honor.
All right. The people can call their first witness.
I'd kind of like to direct you to April 5th, 2023. Do you recall getting a call out for this case?
Yes, it was a general call for service.
And are you aware that there was a 911 call that kind of preceded that call out?
Yes, it was a 911 call for a burglary in progress is what it was coded as.
And did you review the 911 call that was involved in this case?
Yes.
And when you listened to that phone call, did you recognize the voice of the caller on that call?
Yes.
Who was it?
Felisa, the homeowner that I eventually contacted in this case.
Your Honor, the people would move to admit People's Exhibit 1, which is the 911 call in this case.
Ms. Mayberry, do you have any objection to People's 1?
No, Your Honor.
All right, People's 1 will be admitted.
No, what is the address of your emergency? Stay on the line, okay? This is Jeff. I'm with the transfer. It's going to be 9665 West. I'm just going to spell it. David, Adam, Nora, Zebra, Ida, George, Place. What's going on there? I walked in on a robbery at my house. Okay. They walked into your house and there was a female inside your house? Yes, they broke into our gun safe. They take any of the guns? I think so. I ran out of the house. I'm sorry. That's okay. Take a deep breath for me. Did you see them leave your house? Yes, she went through the front door. And you said that they did take the guns? I think so. I ran out. I didn't look to see, but she was in the gun safe. And I don't think there's anything left. Was it just one person? I saw just one person, yes. Just one. The female, can you tell me was she white, black, Asian, Hispanic? Asian or Hispanic. And she had on all white clothing? Yes. Okay, and there was a white hoodie, you said? Yeah, some white pants. Okay, it's okay. When you saw her, did she have any weapons in her hands? No, she was holding my son's Xbox. Okay. But she was in my office in the gun safe.
On that call, did the victim indicate if the person was a male or a female?
Female.
And how did she describe her race?
Hispanic or Asian is what she described it as.
And how did she describe what the person was wearing on their face?
An M95 mask.
Okay. And did she describe what the person was wearing?
All white.
Thank you. And that was with a hood?
Yes.
Okay. And did she also say that she was thin-billed?
Thin-billed, yes.
Thank you. So after that point, where did you transport the victim to?
Hogback Hill Park, which is where my officers had detained the person that matched the description given.
How far was that from the house that was burglarized?
It's a few blocks, not very far at all. A drive less than 2 minutes.
Would it have been within walking distance?
Yes.
And where was, when you kind of got on scene for that show up, can you describe where was the suspect?
Sure. The suspect had been taken out of the patrol car, was standing next to the patrol car with my 2 officers that were on scene, and approximately 20 feet from where my vehicle eventually stopped for the show up to occur.
Were the 2 officers next to the suspect in uniform?
Yes.
And you said it was a patrol car. Was it a marked patrol car?
Yes, marked unit.
Was the suspect detained in handcuffs?
Yes,
And were you wearing body-worn camera on that day?
I was.
And was it working correctly?
Yes,
Have you reviewed that in anticipation of today?
yes.
Your Honor, the people would move to admit People's Exhibit 2 and just do a 1-minute clip from officers' body-worn camera of that day.
Any objection to 2?
No, Your Honor.
Ms. Mayberry, I'm not sure you're appreciating the serious nature of this. You need to be off your phone. Turn your phone off.
I will move to publish People's Exhibit 2, which is a clip of 1850 to 1921.
You can go ahead.
So I just have to ask you these questions. Do you recognize the person you viewed?
Yes,
Okay. If so, from where do you recognize them?
my office, my house.
Okay. And are you confident, somewhat confident, or not confident at all?
Confident.
Okay.
And then and how did she indicate that she knew her from?
From in her home, in her office.
Thank you. There was somebody else on that clip. Who was in the car with you all?
Her husband, she had requested that her husband go with us. She was greatly distressed and had requested that he ride with us while she did the show up.
Prior to the victim indicating that she recognized the victim, did her husband say anything like, "That's her," or did he identify her before the female victim said anything?
No, he said you can't recognize her from the clothes or can't recognize them from the clothes. And that's as we were driving past. She's like, is that them? And she said, I don't. And then he's like, you can't recognize from the clothes. And she said that she needed to turn around. So there was no recognition from him prior to.
Did he ever make statements about his knowledge about the suspect?
Yes.
When was that?
We were going through property that had been located and on the suspect at the time of being detained. And we found a Jeep car key. And the husband then said, oh, I think I know who this person is. And it was all in relation to having found a Jeep car key.
And how did he say he recognized the suspect?
He said that he had interviewed her for an in-home massage therapist position and had elected not to hire her.
Did he indicate how much earlier that interview occurred before this burglary?
I believe it was in January.
Okay, so like in
3 months.
So like in mid-January 2023?
Yes.
Okay.
Ms. Becker, brief argument.
Thank you, Your Honor. In this case, the witness did have the opportunity to observe the criminal at the time of the crime. She did provide a detailed description on the 911 call. The main change here is that she described the individual as being either Asian or Hispanic. I think it's very clear that Ms. Mayberry is African American. The 911 call did indicate that she was wearing an N95 mask, but I do think that that would sort of probably be the reasonable explanation for the difference in race. Otherwise, she was described as having worn all white that day. As seen in Peoples 3 and 4, she is clearly dressed all in white. She also has a white hoodie as described. She was contacted with items from the house that the victims recalled. And then, so the accuracy of the prior description was very accurate in this case. And then when the victim did view the defendant, she was very certain that that was the person she had just seen in her office. And the time between this was only 30 minutes, so it was a very short period of time. So for those reasons, I would ask that defense's motion 10 be denied.
All right, thank you. Ms. Mayberry, any argument you wish to make?
Yes, I would like to make a statement. Your Honor, I respectfully appear today by special limited appearance as the living woman, Michaela Jean Mayberry. I do need to say this on the record for my fundamental understanding, and I speak them in good faith and honor. I'm here today in proper persona, not first pro se, not as a defendant, not as a surety. I'm not representing a legal fiction. I do not voluntarily submit to any role presumed upon me under administrative titles or statutes. I reserve all my rights without prejudice under UCC 1308, and I demand that none be waived knowingly or unknowingly. Do not consent to any contract or jurisdiction not fully disclosed and agreed upon. Notice has already been served, including IRS Form 2848, Form 56, formally revoking office and power of attorney and fiduciary relationship that may have been assumed by this court or its officers. I do not consent to joinder with any corporate entity bearing my name in all capital letters, and I'm not entering a plea. I respectfully stand on my rights. I do not consent to being administrated. I am not here to disrupt. I am not here to argue. I'm here to preserve the record and speak my truth in peace, and request that no adverse inferences be drawn from my silence or non-participation in assumed procedures. I respectfully request that the court intends to proceed to produce on the record a verified claim by a living injured party, a lawful contract bearing my signature, and a proper delegation of authority granting this court jurisdiction over me as a living woman. If this court does not possess those items, I ask that this matter be closed and settled honorably. I do not consent to incarceration, coercion, or compelled contracts. I thank this court for honoring my peaceable notice and my appearance.
If I could just have confirmation from Ms. Mayberry that she's received my emails on the record, then I know that that's a good email for further communications for sending the witness list and exhibit list and instructions.
Ms. Mayberry, have you received those emails?
Okay, Your Honor. No, I'm not the entity the court has created. I am Michaela of the Mayberry family. I am a living woman. And so let the record reflect that I object to any proceedings inconsistent with the Constitution of the United States and the Constitution of this Commonwealth. And I demand this tribunal apply the controlling constitutional doctrine, and any action in contradiction to that, it's ultra vires and void.
Did you receive the emails from the people?
Again, Your Honor, let the record reflect that I object to any proceeding inconsistent with the Constitution of the United States and the Constitution of this Commonwealth. I demand this tribunal apply the controlling constitutional doctrine, and any action in contradiction is ultra vires and void.
Ms. Becker, what I'm going to find is that the people received the email address provided by Ms. Mayberry on Tuesday, that the people have made good faith efforts to provide that information to her. Court has inquired twice of Ms. Mayberry whether or not she received the emails and would neither confirm or deny it, and has made a record accordingly. So I'm just going to make those findings. And anything else?
No, the people will continue using that email address on a good faith basis for providing that information.
All right. All right. The trial starts at 8 a.m., Ms. Mayberry, 8 a.m. on February 9th, 2026. All parties are to be prepared to proceed to trial at that time. Ms. Mayberry, I'm going to go through some of the trial procedures with you so that you are aware of them. So how this is going to work, I'm going to have the attorneys, I'm going to have Ms. Becker and yourself present at 8 a.m. We're going to address any preliminary issues that the parties feel the court needs to address before we bring the jury up. I'm then going to have our clerk go down and grab the jury. We're going to bring up approximately 40 jurors who are going to be on our jury panel. Court is then going to go through and do a full voir dire. Voir dire is questioning of the jury panel to ensure that they are able to serve as fair and independent, fair and impartial jurors in the case. Ms. Becker will then have the opportunity to ask questions of the potential jurors. You will also have the opportunity to ask questions of any of those potential jurors. At the conclusion of your questioning, each side will have the opportunity to exercise what we call preemptory strikes. That means you'll be able to strike at least 5 of the jurors. If we seat an alternate, it'll be 6 strikes. And then through that process, we're going to whittle the jury panel down to either 12 or 13 jurors. After the jury is impaneled, the people will then have the ability to present an opening statement. An opening statement is not evidence. It's essentially an outline of what the people intend on showing at trial. You likewise will have the opportunity to make an opening statement. And then at the conclusion of opening statements, the people will be able to present any witnesses or evidence that they wish to support their case. A couple of things to keep in mind. The people in this case always bear the burden of proving your guilt beyond a reasonable doubt. You are not required to present any witnesses or evidence, as the burden of proof always rests with the people. During the trial, you will have the right to testify. If you choose not to testify, the court will instruct the jury that they're not to consider that silence for any purpose and not hold it against you in any way. If you do testify, the court will go through an advisement with you to ensure that you understand your rights and the implications of your testimony and how that testimony could be impacted. Specifically, because you do have a prior criminal history, the court will advise you that any felony convictions that you have, if you do testify, may be admitted to impeach your credibility. Again, the court will go through this advisement at the trial. At the conclusion of the people's case, you will then have the opportunity to present any witnesses or evidence that you wish to present in your defense. The people will have the opportunity to cross-examine any witnesses called by you. At the conclusion of the presentation of evidence, the parties will have the opportunity to make a closing argument. A closing argument, much like the opening statement, is not evidence. Essentially, it's a summation of what you're going to be asking the court to find based on the evidence that was presented at trial. The court will then review the jury instructions with the jurors, and then they will begin their deliberations. It is critical, Ms. Mayberry, that if you seek to admit any witnesses or exhibits, that you provide those witnesses names and any proposed exhibits to the people in advance of trial. Specifically, you need to file your exhibit list 7 days prior to trial. That needs to be filed with the court. You need to file your witness list 7 days prior to trial. That also is to be filed with the court. If you have any proposed jury instructions, you will not need to submit those jury instructions until the people conclude their presentation of evidence. However, if you do have any jury instructions you wish to propose, those need to be in a finalized manner so that the court can consider them without any undue delay to the jurors. And Ms. Becker, any further advisement?
How long for voir dire and opening?
I would give 20 minutes for voir dire and 10 minutes for opening.
No further advisements. Thank you.
Okay. Ms. Mayberry, understanding the record you made earlier, do you have any additional record you wish to make today?
No, Your Honor, let the record reflect that I object to any proceedings inconsistent with the United States and the Constitution of this Commonwealth. I demand this tribunal apply the controlling constitutional doctrine. Any action in contradiction is ultra vires and void.
All right, we can go ahead and call Mr. Smith's matter if the parties want. That is 25T435. Mr. Smith appears before the court pro se, meaning without an attorney. The last time that we were present, Mr. Smith had sought to relieve court-appointed counsel of her services and did not request new court-appointed counsel, thereby electing to proceed pro se. Mr. Smith, how would you like to proceed in your case?
I filed a motion just this morning. I'm not sure if have you.
It hasn't been filed with the court yet, meaning they haven't uploaded it yet.
Yeah, I hand delivered it just this morning.
All right, so we're looking to schedule a motions hearing. And what type of motion to put the people on notice?
Dismissal.
On what grounds?
Violation of constitutional rights.
All right, so a constitutional-based motion. Are you alleging a violation of a particular section? Or are you alleging that the statute itself is unconstitutional?
It's predominantly the Fifth Amendment, 14th Amendment, in regards to legal counsel and due process.
In regards to legal counsel, you fired your attorney at your last appearance. You haven't sought appointment of a new attorney. In what way have your rights been violated there?
Well, on September 30th, when I was summoned to court on the court's docket to courtroom 103, I went over the building and was unable to find it until I finally intrigued with the guards who pointed me in the direction of the clerk's office. With that being on the docket as a courtroom, and the possible consequences of failure to appear that comes with more fees, fines, and possible jail time. I'm not sure why that's in the clerk's office where I was isolated behind closed doors without that legal counsel, which was before.
So in that instance, you're referring to a different case, not this case, 25R 549. So nothing in relation to that case is going to be referenced in this case. To the extent that you're alleging other violations, though, we'll set your motion for a hearing. Keep in mind that motions deemed to be groundless, frivolous, vexatious, or otherwise contrary to law will not be heard. But I don't have a copy of the motion at this point, so I can't make that determination. We'll set it for a hearing on motions to the extent that any of it relates to this case, not some other case. And let's get a date.
Your Honor, I do have paperwork that does say that that is for the 2025R 000549.
Right, that's a separate case. This is 25T 435.
Okay.
Infraction cases operate under a separate set of rules, and those do get heard for first appearance at the court clerk's office. The case that you're before the court on in this courtroom right now is that 25T 435. So the charges that you have in this particular case are higher level allegations than what you would have been initially for a first appearance authorized to appear in room 103 for the basis of, not the number 4. So again, we won't be hearing any contentions in relation to anything about the infraction case. I'll let you know as well that people are not entitled to have court-appointed counsel in infraction cases, but again, that's separate and apart from you're entitled to have hired attorneys, but the legislature does not authorize public defender or court-appointed counsel or similar to appear on those. And in addition, the district attorney's office doesn't appear on those cases either. All right, for a hearing on motions in this case, I can set a motions hearing on April 1st at 1:30. Can the parties accept that?
That was April 1st?
April 1st,
Yes, ma'am.
1:30.
Yes, ma'am. That is fine. At 1:30.
Correct. As it relates to this case, Mr. Smith, again, 25T 435, we had some of this conversation last week. I just want to make sure to clarify on the record when the people are present that you are electing to proceed to a motions hearing and moving forward in this case by representing yourself. Is that correct?
I'm still in the midst of studying and trying to understand my own rights. So it's a challenge. It definitely is. I'm not going to lie about that. So the representing myself is still pending in my stance of everything, just because I'm in a financial hardship. So finding a free attorney to take the place of a public defender it's almost impossible.
Mr. Smith, I want to reiterate that the last time that we were here, you elected to essentially fire court-appointed counsel and proceed by representing yourself. Is that correct?
That was because I was under the impression that she was unable to defend me.
Unable to ethically file the motion that you sought her to file. Is that correct? According to her.
According to her, yeah, I'm sure.
And you did not seek an alternative defense counsel to be appointed to you. You elected to proceed without the benefit of an attorney at that time. That doesn't mean that you waive your right forever if you can find an attorney, but you were not requesting alternative defense counsel to be appointed to represent you, correct?
No, Your Honor, not from the courts.
And is anybody forcing you to decide to, at this point, represent yourself?
I feel more pressured into it, yes, Your Honor,
In what way?
because I don't have the defense of a public defender.
You had one, you fired her. So in what way are you being forced to do this?
I didn't necessarily fire her, Your Honor. When she refused to even hear me out when I mentioned a few words, that's not, in my understanding, it's not firing her.
We
I
had
was
a
pretty shut down.
lengthy hearing on the last court appearance, Mr. Smith. Do you recall that hearing on the 9th of January?
Yes, Your Honor.
At that time, you no longer wish to have the services of the public defender, is that correct?
Yes, Your Honor.
And you did not seek appointment of alternative defense counsel, is that correct?
Not from the courts, Your Honor.
So that's correct, yes?
Yes, Your Honor.
And did anybody force you to do that?
No, Your Honor. I still feel pressured into it, though.
In what way do you feel pressured?
Your Honor, I was under the understanding that I have the right to an attorney, and if I cannot afford one, then one will be provided for me.
One was provided for you, correct?
Provided for me in the stance that she would not defend me.
And you did not request alternative defense counsel to be appointed to represent you, correct?
Not from the courts, no.
So nobody forced you to make that decision, is that correct?
Yes, Your Honor.
Was that your own choice?
Under coercion, yes, Your Honor.
Who coerced you?
The pressure from representing myself, I was under the impression that that's what you guys were telling me, was since the public defender would not defend me, my only option was to seek my attorney on my own cost and time and effort, or represent myself.
Did you ask for court-appointed counsel, alternative defense counsel?
No, Your Honor.
Are you asking for that now?
No, Your Honor.
Is anybody forcing you to make that decision?
No, Your Honor.
Is it your own voluntary choice?
Yes, Your Honor.
Are you under the influence of any drugs, alcohol, intoxicants, or prescriptions that affect that decision?
No, Your Honor.
Do you understand that you're going to be held to the same legal standard as a licensed attorney?
I'm still under study and research and education of myself.
Do you understand that you're going to be held to the same standard as a licensed attorney?
To an extent, yes.
I'm telling you, you're going to be held to the same standard as a licensed attorney. Do you understand that?
Yes, Your Honor. Do I need to look?
I'm not asking if you understand all of the things that licensed attorneys have had to go through in order to be licensed. I'm asking you whether or not you understand that the standard that you will be held to is that of an attorney.
I understand that part, Your Honor. I just don't understand the standards that they are functioning and operating by.
And nonetheless, you're not asking for alternative defense counsel to represent you. Is that correct?
Not from the courts, Your Honor. I have trust issues.
All right. So you are not seeking to have an attorney represent you, someone who has been trained in this field and is licensed to practice law in the state of Colorado. Correct?
On my own accord and effort and time, I am seeking, so.
And you retain that right always, but you're not asking the court to appoint someone else
No, Your
for
Honor.
you. Is that correct?
Yes, Your Honor.
And do you understand that the top charge against you is failure to display proof of insurance, which is a class 1 traffic offense? You could be sentenced to up to 1 year in the county jail if convicted, or you could receive a fine of up to $1,000 or both, and that one is a 4-point offense. Do you understand that?
Yes, Your Honor.
And nonetheless, you're seeking to move forward, at least at this point, without an attorney to represent you.
At this point, yes, Your Honor. I'm still seeking on my own accord.
But you have filed a motion and you're asking the court to set a motions hearing and you don't have an attorney. So I want to make sure that you are validly waiving your right to counsel before I set this hearing.
I'm under the impression that you're telling me that I still have the right to seek an attorney on my own.
You do, but by filing this motion and asking for the hearing to be set when you don't have an attorney, then we need to talk about the waiver. It's not binding. You can change your mind. You can hire an attorney. However, at this point, asking to move forward without the benefit of an attorney and asking you to set court time aside for a motions hearing does require a waiver of counsel if that is how you want to proceed.
I was not under that understanding at all. No one's here to advocate me as far as legal representation to.
So what would you like to do, Mr. Smith?
I'd like to move forward with the motion.
You want to move forward with the motion?
Yes, Your Honor.
Despite not having counsel?
Yes, Your Honor.
And again, just to confirm, is anybody forcing you to do that?
No, Your Honor.
And you understand the rights that you have. You were appointed an attorney, you relieved that attorney of her services, and you did not request new court-appointed counsel, correct?
To an extent, yes.
To what extent? It's a yes.
To my understanding that the public defender denied me, I didn't deny her.
She is no longer representing you, and you have not requested new
I do
counsel
understand
from
that,
the
Your Honor.
court, correct?
I do understand that, but I was not the one to initiate the denial.
You did not request new counsel, which you
Correct.
could have, correct?
I'm seeking on my own accord, Your Honor.
All right. I do find a knowing, voluntary, and intelligent waiver of counsel. Certainly, Mr. Smith understands the rights that he has to be represented by an attorney. He was appointed an attorney. He did not ask for a new attorney when the services of the public defender were terminated, you retain the right to hire an attorney at your own expense and on your own behalf if you wish, or seek alternative defense counsel. You are not doing so. So at this point, I do find that knowing, voluntary, and intelligent waiver of counsel. We'll schedule a motions hearing on your motion on April 1st at 1:30. Keep in mind that the court cannot accept a letter from someone who is not here to testify or something similar. So if you're seeking to utilize the subpoena power of the state to obtain the appearance at trial of a witness who you may wish to have testify on your behalf, then you can go down to the court clerk's office and have subpoenas issued. And I believe that we already discussed how to get discovery. Is that correct?
Yes, Your Honor, I was provided that.
All right. So I'll note Mr. Smith believes that he has been provided discovery. I would encourage you, you're not required to speak with the district attorney about the facts of the case, but if you periodically want to inquire of their office whether or not any additional discovery has been provided in your case to make sure that there's that free flow of information, I would encourage you to do so. Anything further for Mr. Smith at this time?
Not from the people, Judge.
And Mr. Smith, is there anything further at this time?
No, Your Honor.
All right, so we're going to set that motions hearing as I've stated, and I'll encourage you to be prepared to proceed to the motions hearing. Anything further, Mr.
No,
Smith?
Your Honor.
All right, and I just want to remind you that any allegations brought up in the motion that you filed in 25T435 that relate to the infraction case, which was that 25R 549, any of those issues will not be heard. Any rights that you may have from that case are separate and apart from anything in relation to this case. All right, we'll see you on April 1st.
All right, thank you, Your Honor.